Project Plato, and that was the name that Johnson & Johnson gave to its Texas two-step plan, which is effectively, it was being sued by some 38,000 plaintiffs for having carcinogenic baby powder or other kind of talc powder products, is now liable for some $3.5 billion in settlements and verdicts. So it set up a subsidiary called LTL Management in this case, to shoulder all the litigation and all that burden, and then went to bankruptcy court to file bankruptcy and kind of get rid of it. However, the U.S. Third Circuit Court of Appeals said, you can't do that. You're a $400 billion company. You're not bankrupt. This doesn't work.
This is a classic playbook. So the Texas two-step, if you're listening, again, what Oren just said is you take all of your liabilities, you stick them into a subsidiary, you file BK. And this has been used time in and time out in environmental related litigation, toxic tort, things that you have a lot of long tail claims, so claims that take a while to accrue, and
like cancer,
claims that are like, okay, exactly. So like commonly you see it in like asbestos kinds of litigation, PFAS, you probably see it already in that, these kinds of chemical related litigation matters, which again have long tail claims, which if you're listening, you don't know what long tail is, means it's long, right? It takes a long time for that claim to accrue and for a lawsuit to be filed, and voluminous, right? So when you think toxic tort, you think these chemicals, things, right? These things that can cause folks to get sick. It's usually a mass of litigation. It's not just one or two people. It's, hundreds of thousands of people have been exposed to X, Y, and Z, and that's where this litigation comes from. So commonly speaking, you have 50,000 lawsuits and you shelter it to one company files bankruptcy, and you're out, right? You're like, oh, I don't have any liability. You have to blame company over there.
But this is not the first major company to do this, and not the first major company to do this and do it successfully. So, what happened? Why the change?
It's just a stance. I don't know. Maybe a court is generally speaking, especially like JJ's such a major player. But that being said, there are large companies who have done either the Texas two-step or something very similar. Yeah. Large, massive corporations. So this is definitely unforeseen. Maybe we're seeing a change in how courts approach this method of absolving corporate liability.
Yeah.
But it's something that I personally, when I saw this news, I was taken aback, because this is such a, again, I'm not condoning the practice, but this is such a common practice in this kind of arena. Really took me off guard.
But this is the Circuit Court of Appeals, right? It's not the Supreme Court. I'm sure J&J is going to file this. This could go further, and this could get overturned.
Sure.
Correct? Now, even if that does happen,
true.
But even if that does happen, do other companies now see that there was some sort of hiccup in this plan and maybe think twice about it next time? Or are people just going to keep doing this?
Yeah. No, absolutely. I think you look at this and you're like, how do I learn from this mistake? If it's...
Right.
I mean, generally speaking, you're going to have folks forum shop. I don't want to be anywhere close to this jurisdiction. I don't want to be anywhere close to the Third Circuit. I want to be in a completely different circuit, different bankruptcy court, if I make this maneuver. So I think it's funny because it's called the Texas two-step, but the Third Circuit's not Texas. It would be the fifth. So maybe you can do it in Texas. But it definitely, you're right in that point as well. As I'm sure this is going to be going to the Supreme Court. At least there's going to be a petition to the Supreme Court on this issue, because it is certainly a multi-billion-dollar question, a multi-billion-dollar issue.
Right.
So
exactly.
fully expect that, and agreed. If you're a company and this is your tactic, or at least you just realize that you have a large swath of litigation coming your way, enough litigation that could sink your company if you don't engage in some sort of tactic like the Texas two-step, should be paying attention. Should certainly be paying attention to this.
Now, the Texas two-step aside, just to shine more light on this case specifically, the reason this story we're talking about Project Plato is because that is what Johnson & Johnson internally was calling this maneuver. They were calling this the Project Plato, is how they were going to get out of this liability. Sure. And not only that, but there was a report from Reuters back in 2018 that detailed how Johnson & Johnson knew about the carcinogenic properties in its baby powder, in its talc powder, since the 1950s. And they were dealing with the FDA in the 1970s.
Yeah, it goes back to, listen, in this kind of litigation, you're going to look also at asbestos litigation. It's very similar. It's the same. I think a form of asbestos is in the talc, I believe, is the, and again,
Yes.
if you're listening to this, I'm not an asbestos expert. It's my understanding. There's some horrible, and not just from Johnson & Johnson. I think there are some pretty aggressive, horrible documents across this kind of space where folks were saying, I think there's a famous one in asbestos where it's like, if you live, horrible. I think it's like, if you live by asbestos, you live as a result of asbestos, you die by asbestos. Some horrible document. And that's what you find in this kind of litigation, especially in the toxic tort realm. Again, I'm not saying Johnson & Johnson. I'm not speaking to liability for Johnson & Johnson. This is the lawyer coming out in full force. Like, Johnson & Johnson, you're listening to this, like, I don't know, right? Because I'm not the jury, I'm not the trier of fact. But that being said, in this type of arena, it is heavily litigious, and there's certainly a history to it.
Right. Now, to tie it back, does that then change? Does that affect the opinion of the 3-judge panel at the circuit court? Does that affect?
No, because it's my understanding. I believe there have been, for asbestos is the most common comparison. I believe like there has been the same kind of tool utilized. I say legal tool in the asbestos arena. So it's happened before. Like this, yeah.
Well, change course this time, and we'll see if it goes to the Supreme Court or what happens next. But it'll be interesting to find out.
Hey, I hope you enjoyed this episode. If you did, like and subscribe wherever you get your podcasts. Check us out also on LinkedIn and Twitter to keep up to speed with what we're doing. Catch you on the next one.